Oh, hello. Happy Tuesday, everyone. So, I wanted to address, I was going to address the Taylor Swift thing actually, because I've had a few people ask me about it. I've got a few opinions on the, so there's news that Justin Baldoni's process server was arrested for trying to subpoena Taylor Swift at 2:00 in the morning by jumping over a fence or a gate or something like that. I'm not really gonna delve into that much at all. I have an issue with the news outlets still falsely reporting that Judge Lyman denied Wayfarer's request to depose Taylor Swift when that is not true at all. He just denied the request for an extension. But Taylor Swift can still be deposed anytime in the next week. Hi, Jane. So I wanted to say, like, I struggle when to take any kind of give any credibility to news outlets who are misleadingly reporting on that and unable to read a court order correctly. But as I have been asked, what do I think about this process server and what he did? I'm not entirely sure it's a true story. There's a few red flags for me. There's three big ones, actually. Firstly, the rules around process servers, they vary state to state, but I would expect that there would be some kind of universal agreement that it would be considered improper service to try and gain unauthorized access to a gated community in the middle of the night. Just to put that out there, if that's how the subpoena was attempted to be served, then already that's grounds for a complaint that it was served improperly. It would be a complete waste of time and money. And I just can't see a credible process server doing that. Then the second point is Wayfarer, they were in contact with Taylor Swift's lawyers, with Douglas Baldridge at Venable. He even filed a letter on the docket as recently as the 12th of September. So that's 11 days ago. And that was literally in response to whether she would comply and sit for a deposition. So I don't see why they wouldn't be in communication, would continue to communicate with the lawyers rather than trying to serve a subpoena on Taylor Swift at Travis Kelce's house. It doesn't make sense. And then the biggest red flag is if Taylor Swift really has been harassed and, had someone attempt to gain access to the property she's staying at 2:00 in the morning, Blake Lively hasn't rushed to file something on the docket to tell Judge Lyman about it. That's not her usual MO. Yeah, I agree with you, Sean. I think it's a stalker or an opportunist. Could be something related to Ryan Reynolds, Blake Lively. A few people have hypothesized. Possible. I don't know. Possible. More plausible than Justin Baldoni asked, and Wayfarer in general, asked the process server to try and serve someone, Taylor Swift of all people, a subpoena at 2:00 in the morning. So that's my thoughts on that. And that's probably all I am going to say about it because I think the story's ridiculous. I think it's a PR spin. Hi, everyone. It's just coming in. I'm on my own, so I'm quite nervous, as always. But Happy Tuesday. Tuesday means that actually I watch a program on Disney Plus called Only Murders in the Building. It's got Martin Short and Steve Martin and Selena Gomez on. And Tuesdays are the day that a new episode drops, and I haven't watched today's, and it's like 10 o'clock in the night for me. Does anyone else watch that? It's a really awesome series. If no one watches that, they really should. It's great. It's funny. Oh, do you watch it, Jane? Hi, Gelly. I did see that. Yeah, what this guy's name was also called Justin. I saw that as well. That's I mean, I think that's just a coincidence. So I'm not reading too much into that. You know, she's already kind of said, Taylor Swift has already kind of said, like, well, you know, if I have to sit for a deposition, then I've only got these dates available. I mean, she wasn't even fighting it. So, you know, I just don't see a need for anyone to try serving her silly o'clock at a really inconvenient time. So that's just my thoughts. Okay. So I got quite excited by the filing from Wayfarer responding to Lively's request for remedies under Section 47.1. I don't normally come on and do a live stream about these things, but I was enthusiastic about this particular filing. So I was going to read it and just kind of maybe talk about a few points. I did do an X post, but I appreciate that not everyone's on X. So yeah, I've got a few thoughts on this, and I'm happy to try and answer some questions as well if anyone has any. Unfortunately, though, when I'm kind of reading the screen with the filing on it, I can't see the chat, so I'm not ignoring anyone, and I will come back and read the chat. Okay, so for the second time, plaintiff Blake Lively seeks draconian relief under a new California statute, California Civil Code, Section 47.1, which creates a qualified privilege for any person claiming sexual harassment under defined California statutes, including FIHA and California Civil Code, Section 51.9. And I'm just going to get my glasses because I'm struggling. There we go. Now I can see. Section 47.1 authorizes an award of reasonable attorney's fees. And that's important because a lot of people thought it was going to be the treble damages also included treble attorney's fees, and that's not the case. So authorizes an award of reasonable attorney's fees, treble damages, and punitive damages for a failed defamation claim against a party asserting sexual harassment claims without malice and with a reasonable basis to file a complaint of sexual assault, harassment, or discrimination. Thus, whether the privilege and remedies afforded by Section 47.1 apply turn not on the Wayfarer party's underlying conduct, but on Lively's motive and intent. Whether Lively inserted the claims without malice and with a reasonable basis. Factual issues that remain to be tried in the case. And I've got 2 points to kind of say on this. I'm just going to switch screen briefly, because back on March the 21st, I said this. And not a lot of people really mentioned this, and I've seen many people assume that because she's made a complaint, and she didn't have to file a complaint, she just needed a reasonable basis to have made a complaint, and because Wayfarer effectively Lively was the prevailing party when Wayfarer's claim for defamation was dismissed against her. A lot of people thought that she would automatically be awarded all these remedies under section 47.1, but that is not the case because it is a qualified privilege. So here, this is my post from the 21st of March, actually. It does not automatically apply just because Lively has complained of sexual harassment. And section C actually says, this section shall only apply to an individual that has or at any time has had a reasonable basis to file a complaint of sexual assault, harassment, or discrimination, whether the complaint is or was filed or not. And that means the complaint must be made in good faith, and there must be a reasonable basis for that. And I went through all of that. Like, starting point was a definition. What is sexual harassment? Well, Justin Baldoni saging a set is not sexual harassment. Justin Baldoni claiming to talk to her dead father is not sexual harassment. And Justin Baldoni crying in his trailer is probably not sexual harassment either. Some of her complaints probably do meet the criteria. So, but there is explanations for them as well. The use of the word sexy, for instance, my example here, this was a director describing the particular look of a character's wardrobe. As Lively herself had set the precedent for use of the word in this context, it's difficult to see how she could claim it's unwelcome or uncomfortable. And I kind of did that for a few things, like demand for the intimacy coordinated at all times, the home birth video, improvised kissing, asking about weight, the birth scene, so on and so forth. But aside from the good faith, she also has to prove that her claims cannot be made with malice. And I think she's going to struggle there. So I'm glad I was excited to see that these points coming back and finally someone saying, well, hold on a minute, just because you've said this does not mean that, you have, and just because our claims were dismissed does not mean that, you met the criteria under section 47.1 for this award. So, Wayfarer do point that out incredibly well. The other thing they do is they refer you to a footnote 2. They've redacted what is said, but Baldoni's WME agent, former WME agent, Danny Greenberg, has clearly testified something. We don't know what it is, but there's already a letter in process where which explains to the judge that Wayfarer and Lively are currently having meeting confers to decide whether the portions of testimony from I believe it's Lively's makeup artist and her WME talent agent, and Danny Greenberg, Baldoni's former WME talent agent, see whether they still need to be sealed or whether those portions of deposition transcript can be unsealed. So hopefully we will see them unsealed soon. As explained in section 2A below, section 47.1's express language raises multiple constitutional concerns which have not been addressed by any California or other court, including its curtailment of free speech and the litigant's right to petition guaranteed by the First Amendment, as well as potential violations of the Fourth Amendment's prohibition against excessive penalties, treble and punitive. So, and they mention a little footnote there that this is going to be a case of first impression because no court has ever addressed Section 47.1. So no pressure on the judge. Further, Lively does not explain why California's presumption against extraterritorial jurisdiction does not apply to Section 47.1 when Lively is not a California resident and the alleged harassment, which is the basis for her claims, occurred in New York and on the New Jersey set where It Ends With Us was filmed. Lively, the statute, and its legislative history are also silent on whether these remedies are available for dismissal of a consolidated complaint, where the issues of liability and punitive damages have not yet been determined by the trier of fact. And obviously, the trier of fact is either going to be the jury if it gets to trial, or it will be the judge if, if he rules on summary dismissal. The extreme remedies created by Section 47.1 require factual findings that Lively asserted her claims without malice and with a reasonable basis. This inquiry turns on Lively's motives, to wit, whether her complaints of sexual harassment were made with malice and with a reasonable basis, factual determinations within the province of a jury or the court on summary adjudication based on admissible evidence. No trier of fact has made these factual determinations, which are central to Wayfarer party's defence and will be ultimately determined in the still pending main action. Although Lively contends that to be effective, the remedies should be imposed at an early stage of the litigation, neither the statutory language nor its legislative history address the dismissal of a consolidated complaint before the complainant's sexual harassment claims are tried in the main action. Lively, nevertheless, contends that Section 47.1's remedies must be available at the earliest stage, typically through the motion to dismiss, to protect survivors from a punishing, protracted legal process. And I had a problem with that in her motion. This request is kind of attached to the fact that Wayfarer's counterclaim was dismissed, but Lively initiated the legal process. Lively filed first. Wayfarer filed initially against the New York Times, not Lively. And they did that on the same day that Lively filed this lawsuit in New York. They subsequently counterclaimed against Blake Lively in New York, but even though Wayfarer's claim has been dismissed, her claims that she has brought are ongoing. So it's not going to, the awarding her anything at this stage is not going to protect her from any punishing, protracted legal process, especially one that she chose to initiate. Here, however, neither the dismissal of the Wayfarer party's defamation claim nor an award of penalties under Section 47.1 would achieve this statutory goal of preventing ongoing protracted litigation over the same factual issues which determine the applicability of Section 47.1, to wit, whether Lively's claims are valid. No California court has provided guidance on this issue, including whether a court's determination before trial in the context of Section 47.1 of the complainant's motive and intent would divest a defendant of his right to a defense at trial or by summary adjudication based on admissible evidence. I'm just going to have a quick look in the chat and see if there's a... Oh, hi, Christina. Yeah. Hi, Neil. Oh, have a good night, Sean. Thank you for coming. Right, okay. Oh, hi, Raffle. Right, I'm going to go back and continue. The application of Section 47.1 to the dismissal of a consolidated complaint while the main action is still pending also raises the spectre of inconsistent outcomes. For instance, if this court applies Section 47.1's privilege and remedies at this early juncture, what happens if a jury later finds her claim lacks merit? And this is an absolutely brilliant argument, a very good point. What if the judge finds in her favor, grants her all these remedies, and then at trial or at summary judgment, her claims are found to be lacking merit, and effectively Wayfarer prevail? Like, how do you balance that? I think the Wayfarer are really not making it easy for the judge in this situation. I think they're offering him a lot of outs to deny this request from Lively. Excuse me. Nor has any California court explained how punitive or treble damages can be calculated without a baseline finding of actual compensatory damages by the trier of fact. Lively, in fact, does not directly address the key issues of her motive and intent, but deflects by recycling the full breadth of her allegations of the Wayfarer party's purported misconduct, which are the basis for pending Rule 11 and New York Rule of Professional Conduct 3.6 sanctions motions. The bulk of these allegations have no bearing on the discrete factual issues relevant to a Section 47.1 analysis, specifically whether Lively had a reasonable basis for her sexual harassment claim and acted without malice in asserting it. For instance, Lively argues that the court dismissed the Wayfarer party's defamation claim against Ryan Reynolds and Leslie Sloan for failure to plead malice, sufficient evidence of a smear campaign, and strong evidence that the Wayfarer party spread negative stories about Lively. Whether the court found that the complaint failed to plead malice sufficient to state a defamation claim against Ryan Reynolds, Leslie Sloan, or the New York Times, or spread negative stories about Lively is irrelevant to Lively's motive and intent in asserting her sexual harassment claims. And the court did not dismiss the Wayfarer party's defamation claim against Lively for failure to plead malice. Rather, the court found that Lively's complaint, the only basis for the defamation claim asserted in the cross-complaint, was privileged under California's litigation and fair report privileges, and thus it was unnecessary to reach the issue of malice. Sorry, I'm just going to grab a drink. My throat's getting dry. Notwithstanding Lively's exhaustive rehashing of the full breadth of her allegations, the motion before the court remains short on the relevant factual issues and devoid of legal authority that might allow the court to award punitive remedies provided in Section 47.1 at this stage of the litigation. Lively's motion should be denied because, among other things, Lively fails to show that Section 47.1 or the California Civil Code Section 3294, which is California's punitive damages statute, have extraterritorial application. Lively fails to present new facts or law that might warrant reconsideration of the court's previous denial of relief under Section 47.1. No trier of fact has found, based on admissible evidence, that Lively's sexual harassment claims were asserted without malice and with a reasonable basis. Lively fails to show, and no trier of fact has found, clear and convincing evidence that the malice required for punitive damages as required by Section 3294, and plaintiff has not proven, and no trier of fact has found, the actual compensatory damages required as a basis to calculate treble or punitive damages. And that's all true. So, plaintiff's motion should be denied. And then they go through each of those points in a bit more detail. So, firstly, we've got no California or other court has addressed the constitutional concerns and conflicts apparent from the face of Section 47.1. Okay. Plaintiff's motion implicates two California statutes, Civil Code Section 47.1, which applies to sexual harassment claims under certain enumerated California statutes, including FIHA, and Civil Code Section 51.9, and Civil Code Section 3294, California's punitive damages statute. Lively seeks remedies under California Civil Code Section 47.1, which provides for severe penalties for unsuccessfully filing retaliatory defamations action against sexual harassment and retaliation complainants. According to plaintiff, according to plaintiff, the recently enacted Section 47.1 was intended to deter frivolous claims that force survivors to defend against long and expansive retaliatory defamations lawsuits by imposing significant remedies for success defendants in defamation claims, and was intended to protect victims from the litigation itself. As a preliminary matter, Lively does nothing to address the constitutional concerns and conflicts raised by Section 47.1's express language. First, Section 47.1 conflicts with the right to free speech and petition guaranteed by the First Amendment to the United States Constitution. Section 47.1 also clashes with the Noor-Pennington Doctrine, which provides that those who petition any department of the government for redress are generally immune from statutory liability for their petitioning conduct. By imposing a statutory penalty on plaintiffs for unsuccessfully bringing certain types of lawsuits, even when they do so in good faith, Section 47.1 appears to trespass on the Noor-Pennington immunity doctrine. So, let's just switch screens again, because on the 4th of April, I did this post. And this was in response to, this post was about Wayfarer's response to Lively's motion to dismiss, where we heard about Section 47 for the first time, and they raised the Noor-Pennington Doctrine. And I explained a little bit of what I found out about it. And basically, the Noor-Pennington Doctrine, this is my view, effectively gut punches Lively's immunity claim. I don't have case law to refer to, but interpreting the way Wayfarer have used it here and its use in other cases, it appears that the doctrine is intended to apply as a defence to Wayfarer, the parties, seeking redress from a government agency, the federal court, where their First Amendment right is implicated and the action was brought in good faith. I'm not very familiar with this, and in this case, Wayfarer confirmed themselves that this would be a matter of first impression. In other words, a precedent-setting landmark case. So, that's a bit about what the Noor-Pennington Doctrine is. and how it would apply in this case. And I stand by that. I still think that she's got a hurdle to get over to defeat the null penitent immunity doctrine. Second, plaintiff fails to address how Section 47.1 can be reconciled with California Civil Code Section 47B, which, consistent with the right to petition, creates an absolute to bar any defamation claim based on statements made in connection with a judicial proceeding. Specifically, Section 47B applies to any communication, 1, made in judicial or quasi-judicial proceedings, 2, by litigants or other participants authorized by law, 3, to achieve the objects of the litigation, and 4, that have some connection or logical relation to the action. And there is a bunch of case law here. The privilege is absolute and applies to all publications, irrespective of their maliciousness. For clarity here, though, Wayfarer are referring to the litigation privilege. So, then they're citing a bunch of cases here. Just trying to highlight, including their own. Including their own. The privilege is absolute and applies to all publications, irrespective of their maliciousness, right? And they cite their own dismissal. Basically, this is a decision Judge Lyman made on the claim against Lively, where he said, well, she's protected because of the CRD. And they cite they quote a bunch of cases, which basically reaffirm that the litigation privilege is an absolute privilege. So what Wayfarer are basically doing here, quite cleverly, is saying to Blake Lively, I see your qualified privilege, i.e. the sexual harassment privilege under Section 47.1, and I raise you my litigation privilege because there's an incompatibility here. By claiming all these damages and punishing me for bringing an action against you, that is incompatible with the absolute privilege that the litigation privilege gives us. And that's what Wayfarer are doing here, and is really good. Third, plaintiff fails to explain how Section 47.1 should or can be applied when, as here, a defamation claim is dismissed at the pleading stage before the dispositive factual issues of whether the plaintiff's claims were asserted with malice and without a reasonable basis, issues of fact within the province of the jury. In the same vein, Section 47.1's approach to punitive damages under California Civil Code Section 3294 is particularly troubling. As explained in Section 2E below, California has a long-standing rule that there is no right to punitive damages. So there's no automatic right to this. Even if she prevails, it's not a given that a jury would award her punitive damages. And punitive damages are they're damages that can be awarded to punish someone. They're not like damages like your losses, etc., injuries. They are an additional set of damages which would be awarded to punish someone else. So like Amber Heard, in her case against Johnny Depp, I think that if I remember correctly, they awarded something like $5 million in general damages, but then they awarded another $10 million. I know it was reduced because there was a cap in Virginia, but the jury awarded a further $10 million in punitive damages because that was to punish her for her acts. I hope this is making some kind of sense. So California does not have an automatic presumption of punitive damages. Rather, punitive damages require clear and convincing evidence of malice, a determination left to the discretion of the trier of fact based on admissible evidence. Where a trier of fact finds that punitive damages are warranted, the Fourth Amendment's prohibition against excessive penalties limits such damages to a maximum of 3 times the actual compensatory damages awarded by the jury. The questions of whether Section 47.1 permits punitive damages to be awarded as a matter of right, or how punitive damages would be calculated absent an award of actual damages, where a defamation claim has been dismissed on a motion to dismiss, have not been answered or even addressed by any court. Nor does plaintiff explain, much less cite authority for how the court can calculate punitive or treble damages without an award of compensatory damages. So, all good points. The plethora of serious constitutional and other legal questions have not been addressed by any California court, raising the preliminary question of whether this court, as a matter of first impression, should apply Section 47.1 to impose the draconian remedies of attorney's fees, treble damages, and punitive damages without any answer to or even guidance on these critical questions and concerns. And when I did my thread earlier, I actually, what I said was, this almost sounds like Wayfarer are throwing down the gauntlet to the judge and saying, okay, no court has given any guidance, they've never weighed in an opinion, this would be a case of first impression, it's on your desk. By the way, there's all these constitutional conflicts, all these questions about it. I dare you to rule on this if you're brave enough. But it feels like, they're almost not calling his bluff. That's not the right. I know what I'm trying to say. Like I dare you. Because most judges will not want to do this. They will not want to be the one to sit and make a decision on, especially a case law, a statute like this, where you've got sexual harassment involved for the first time. So that's how I took that. Neil, that's awesome. You're having sausage, egg, and chips for tea. I hope you enjoy it. Oh, everyone's talking about the dinner. Chard and a cream sauce with noodles and fresh tomatoes. That's different. That's interesting. Okay. Oh, hi, Christine. How are you? Okay. Christina, I really want to know what you won now, so I'm going back through the chat. You won the battle with the refrigerator water filter? What's that about? Oh, I'm going back through the chat now to find out what that is. Hi, Kay Bella. All right. Okay. So, it may have been for some or all of these reasons that the court has already declined to award Lively the relief she seeks under Section 47.1, albeit without prejudice. In doing so, the court explicitly noted that it had not ruled on whether Lively's statements were privileged under California Civil Code Section 47.1, and that if Lively chose to renew her motion, she should fully brief the impact of this opinion, if any, as well as the issues raised in prior briefing. While Lively now resuscitates her motion with an extensive exposition of the facts asserted in prior pleadings and the order, she does a reasonable basis for her sexual harassment claims and whether her claims were asserted with malicious intent. Simply put, nothing has changed since the order and Lively, and this renewed motion appears to be nothing more than an improper request for reconsideration, seemingly contrived as a thinly veiled effort to poison public perception and the potential jury pool. As best, the motion is premature. The court should decline Lively's invitation to interpret Section 47.1 as an issue of first impression in the dearth of any guidance from any California court and impose heavy-handed penalties, which would require this court to make premature factual determinations. Yeah, I think we're all over Section 47.1, Jane. Right, okay. I'm just quickly checking something a minute. Right, be packing. Okay. Haley, I've just sent you a message. Could you just read it for me, please? Where were we? Plaintiff fails to show that Section 47.1 or Civil Code Section 3294 may be applied extraterritorially. The threshold question is whether these California statutes have extraterritorial application, whereas here the plaintiff is a resident of New York and the underlying conduct occurred in New York and New Jersey. The California legislature knows how to create exceptions when that is its intent and when a statute gives no clear indication of an extraterritorial application, it has none. California recognizes a presumption that the California legislature did not intend a statute to be operative with respect to occurrences outside the state unless such intention is clearly expressed or reasonably to be inferred from the language of the Act or from its purpose, subject matter, or history. My voice is going. So they quote a bunch of cases here to kind of reinforce that. They're having a battle over the jurisdiction now. I won't read all of them. Although proposed amici curiae offered in support of Lively's position quote extensively from Section 47.1's legislative history, Lively does not point to express language in Section 47.1 or any portion of the legislative history that even hints at an intent that the statute have extraterritorial application. In fact, Section 47.1 does not include any affirmative action that it was intended to apply to conduct outside of California. Likewise, nothing in the legislative history of Section 47.1 indicates the legislator had any intent for this statute to operate outside California. Because Section 47.1 is silent on the geographic scope of its application, and there is no expression of legislative intent for it to apply extraterritorially, the presumption applies in full force and lively. A non-resident of California cannot invoke it for conduct occurring outside California. Absent the express or implied showing of an intent of extraterritoriality, Lively must establish a substantial connection between the situs of the legally relevant conduct and California specifically, the location of where the core of the alleged wrongful conduct occurred. Sorry. A formulaic conclusory blanket recitation of ratification is insufficient to overcome the presumption absent facts sufficient to establish a factual nexus between the defendant's California-based activities and the allegedly wrongful conduct. And one of the thought processes I had here was that in Lively's loan out agreement, the choice of law was California, and I wasn't sure how they were going to approach that, but they do actually address it and say, nor does a contractual choice of law provision overcome the presumption that a California statute lacks extraterritorial reach. Neither Lively's complaint nor the motion state facts sufficient to establish a substantial connection between the Wayfarer defendant's unsuccessful defamation complaint filed in and dismissed by a New York court or the underlying sexual harassment claim which would give rise to the privilege she seeks to invoke. Lively is a New York resident. They clearly have seen her Instagram posts. The core conduct alleged sexual harassment on the It Ends With Us set and the filing and dismissal of the Wayfarer party's unsuccessful defamation claim, the basis for Lively's request for remedies under Section 47.1, did not occur in California, but in, and they've redacted that bit. So that's part of Exhibit A, Exhibit B, and Exhibit C. Okay, so that's redacted for now. While Wayfarer is headquartered in Los Angeles, the employee or employer's residency is not sufficient to overcome the presumption when the torturous conduct is outside of California. The failure to demonstrate a substantial connection between the situs of the core conduct and California defeats any notion that Section 47.1 or 3294 can be applied extraterritorially. Because she cannot overcome the presumption against extraterritorial application of Section 47.1, Lively's request for relief under Section 47.1 should be denied. Section 47.1 cannot apply where, as here, there are no factual findings that Lively's claims were asserted without malice and with a reasonable basis. Section 47.1 creates a privilege for communication made by an individual without malice regarding an incident of sexual assault, harassment, or discrimination is privileged. So long as the speaker has, or at any time has had, reasonable basis to file a complaint of sexual assault, harassment, or discrimination. The Wayfarer defendant's defamation claim was dismissed pursuant to Rule 12b(6) for failure to state a claim. The order dismissing the claim expressly states that the court did not consider whether the Wayfarer parties pleaded malice, but dismissed the claim based on privilege grounds. Plaintiff's harassment claims remain pending, and in the merit of those claims, as well as Lively's motive and intent in asserting them, will ultimately be decided by a trier of fact, a jury, or the court in the context of summary adjudication. Indeed, a centerpiece of the Wayfarer party's defense is that Lively's claims have no merit and were asserted for an improper purpose. The jury must resolve the threshold question of the defendant's knowledge of facts on which his or her claim is based. Plaintiff does not explain how the court might eliminate the risk of inconsistent findings on the pivotal issue in this case, Lively's harassment claims. Should this court prematurely decide that Lively's sexual harassment claims were asserted without malice and with a reasonable basis? So that's a really good point. Inconsistent findings. Nor does plaintiff provide any authority for the notion that the Wayfarer defendants can be stripped of their rights to a defense at this early juncture in the context of Section 47.1 motion. Lively similarly fails to identify new facts that might support her motion. Plaintiff merely resuscitates the allegations set forth as the basis for plaintiff's pending motions for sanctions under Rule 11 and New York Rule of Professional Conduct 3.6. The bulk of the allegations have no relevance whatsoever to this motion, which is not about the Wayfarer party's motives or conduct, but about Lively's motive and intent. In fact, Lively's motion is laden with extraneous and irrelevant facts. For instance, Lively argues that Wayfarer's defamation claims against Ryan Reynolds and Leslie Sloan were dismissed for failure to plead malice. Lively ignores that even assuming a pleading defect can be the basis for Section 47.1 remedies, the court did not base the dismissal of the Wayfarer party's defamation claim against Lively on this ground, but rather on the ground that it was subject to California's litigation privilege and the fair report privilege. And I'm just going to come and check back in with the chat. Let's see. Is it because her hair can be in two states at once? I would take it we're talking about Blake Lively's frizzy do. That's a good point. We have, I'm going to take this opportunity actually to plug this. On Sunday, we are doing a special edition stream, and I'm being joined by, so far, Cassidy has confirmed, and Same Girl, Different Time has confirmed. I'm waiting on 2 other people to see if they're joining as well, make sure that they are available, but we are doing I want to say like a birthday celebration for Van Zandt. So I hope people can join us for that. Should be awesome. I'm just going quickly through, see everyone. Oh, thank you, Haley. Yes, this was written by Ellen the Great. How can Blake use this Tuesday? So, do you know, it's a really good question. You know, it's Jed Wallace, everything's in New York, but, you know, for her, I think what Wayfarer are alluding to is she's taken advantage of a law in California. Hi, Max. Yes, they do have a history. So are you asking if CJ's going to be joining us? I mean, I'll ask her. That would be nice if she would, but I mean, she's been very busy, so and she's been poorly recently. At the beach, why can Blake Lively change her story? Well, she can change it, but people will pick up on it, and she will be torn apart, especially at trial. All of these changes will be brought up in front of her, and she'll be questioned. Why did you change your story? There's any number of reasons why she's doing it. Like, I did a pre-recorded video, I think it was yesterday, on why I think she changed the timeline of the smear campaign from around August last year, around the premiere time, and then she seemed to, in a filing, say that it happened during production, which could go as far back as April 2023. So that's a huge change. And I think it's because Colleen Hoover at that time, around between January and April in particular, 2023, received huge blowback because she tried to market a colouring book. And Blake Lively would have been aware of that because she was already on board with the film. She was, you know, part of the production. She was, you know, helping with the script changes. In April, we had the rooftop scene and the whole dragons text, that was in April. So she was well aware of that pushback Colleen Hoover had for the colouring book. And I said in my video, I cannot believe she went out of her way to make identical mistakes. I think her ego let her think that, you know, that she wouldn't get the pushback. Or if she did, it wouldn't be that bad. She'd be able to weather it, but that was not the case. I think Colleen Hoover got the smaller pushback because it was from her Colleen Hoover fans, her book talk fans. Blake Lively, when she tried to do exactly the same thing, market something totally inappropriate for a domestic violence film, the film was on a global scale. So Blake Lively's pushback was on a global scale. Yes, exactly, Haley. But yeah, my video, I went through it in quite a lot of detail. So if you haven't checked out that video, please do. I do think, yes, you can't find evidence to fit a timeline. No, exactly. She's even having to bring in someone from a different project and get them to write a declaration to support her. You know, that really tells me that she's got nothing. So, does Lyman have to rule on this motion for treble damages, or can he sit on it until after summary judgment? He can do any of those things. It's his court, so he really can. He has a discretion, or he could do it now. Blake Lively has asked for a hearing as soon as possible. He could do that. He may wait until summary judgment is decided and do it then, or he could just let it get to trial, see what the outcome is. I think that is the more likely, because he's also not ruled on Leslie Sloan's motion for her attorney's fees and costs. So I think he is. If I was in his position, I would be waiting until we have like a definitive end point, and we have an outcome in this. I would not want to be ruling on this now. So I hope that answers the question. So let's go back to this. Plaintiff has not proven that she is entitled to punitive damages under Section 3294. While a plaintiff who proves his case is always entitled to actual damages, a plaintiff is never entitled to punitive damages as a matter of right, not even upon the clearest proof of malice, in fact. For an award of punitive damages under California Civil Code Section 3294, a plaintiff must prove by clear and convincing evidence that the defendant acted with malice, oppression, or fraud in bringing the defamation cross-complaint. Malice is defined by Section 3294, subdivision C1, as conduct which is intended by the defendant to cause injury to the plaintiff or despicable conduct which is carried on by the defendant with a willful and conscious disregard of the rights or safety of others. Despicable conduct is conduct that is so vile, base, contemptible, miserable, wretched, or loathsome that it would be looked down upon and despised by most ordinary, decent people. Such conduct has been described as having the character of outrage frequently associated with crime. Conscious disregard means that the defendant was aware of the probable dangerous consequences of his conduct and that he willfully and deliberately failed to avoid those consequences. Put another way, the defendant must have actual knowledge of the risk of harm it is creating, and in the face of that knowledge, fail to take steps it knows will reduce or eliminate the risk of harm. In the defamation context, to show actual malice, plaintiffs must demonstrate a defendant either knew his statement was false or subjectively entertained serious doubt his statement was truthful. So in this context, we're not talking about Blake Lively, her actual malice. We are talking about Wayfarer. She has to prove that that Wayfarer's conduct was done in malice too. The clear and convincing standard presents a heavy burden far in excess of the preponderance sufficient for most civil litigation. The burden of proof by clear and convincing evidence requires a finding of high probability. The evidence must be so clear as to leave no substantial doubt. It must be sufficiently strong to command the unhesitating assent of every reasonable mind. Whether a defendant acted with malice is an issue of fact for the jury, and it is within the exclusive province of the jury to say whether or not punitive damages shall be awarded. And the granting or withholding of punitive damages may not legally be influenced by any direction of the court. Plaintiff simply ignores the requirements that malice be proven with clear and convincing evidence. Any finding of malice and punitive damages is within the exclusive province of the jury, and the court is prohibited from influencing the jury's decision on whether to award punitive damages. Instead, plaintiff avers that, as for punitive damages, the record as it currently exists is sufficient for the court to determine the Wayfarer parties engaged in oppression, fraud, or malice by bringing or maintaining their claims against Miss Lively. This argument, while factual, is contrary to the law. So, and that is obviously in reference to California's law that there is no automatic right to punitive damages. Plaintiff fails to explain how, in the absence of actual damages, the court can calculate punitive or treble damages. Punitive damages typically require a finding of actual compensatory damages. An exception exists where a plaintiff is entitled to recover presumed damages. Neither Section 47.1, FEHA, nor Title VII provide for presumed damages. Hence, an award of actual damages is a predicate for any award of punitive damages. There has been no award of actual damages after a trier of fact has found liability. Plaintiff similarly getting tired now. Plaintiff similarly fails to explain how the court can calculate treble damages absent a finding of actual compensatory damages. Put another way, what exactly would the court be trebling? And that is an absolutely brilliant way to end that section. Conclusion: for the foregoing reasons, the Wayfarer parties respectfully request that the court enter any or... Oh, I'm getting tired now. For the foregoing reasons, the Wayfarer parties respectfully request that the court enter any order denying Lively's motion for relief under Section 47.1. So there we go. That was actually a really good motion, and I think it's going to bind the judge. I can't see how the judge is going to fold himself into some kind of origami bird to try and grant that to Blake Lively, because Wayfarer put layer upon layer upon layer of tight law, and they have thrown everything at this one, and I absolutely love it. So, Neil, thank you. So I think this is a great file, and I was really excited by it. I'm glad to see Noor Pennington doctrine coming back in as well, because that was mentioned, and then there seemed to be silence on it. But and for a moment I thought, right, okay, maybe Wayfarer have kind of just dropped that, but no, they haven't. Potentially, because this is a case of first impression, it has the potential to go all the way to the Supreme Court of the United States. This could be a huge deal. I would be surprised if Blake Lively actually let it get that far. Is my opinion. Angela, thank you so much. That's really kind. Oh, thank you, Christy. I try my best. Oh, thank you so much, Heidi. I love you. Yeah. So I wanted to just kind of come read it. I don't do readings because I'm really mindful other people do it, especially Lauren, and I do my stuff and I try not to verge into other people's areas. But this one really I got quite excited about because it has some complex things in it. So I did my thread. I spent quite a long time doing the thread because there was just so much to unpack in that filing. I'm aware not everyone has X. And there are things like some thoughts and opinions I had as well I really wanted to share and get off my chest. But I hope that helps. If anyone's got any questions. Oh, Newton the Owl. Right. Yeah, if anyone's got questions, please do like put them in the chat. I'll try and get to some of them. Newton the Owl. Okay, so the owl was designed by Eiko. I'm sure you all know Eiko Ishiwata, Brett McDowell's wife. Eiko is an artist, she's video designer and so on and so forth. Now, and she's a very good friend of mine. I approached her because I wanted a little mascot, but I wanted some, like I love owls, and they kind of give, I don't know, there's a representation with owls in there with education and intellect. And I think I was inspired by the owl in The Sword and the Stone, the Disney film, Sword and Stone, Archimedes. So I said to Eiko, I'd really love something similar to that. And then we kind of put it together with my 6-year-old little girl in mind. I got a daughter. She's not got good health. She needs round the clock care. So we designed something where I could turn into a little plush teddy for her, but also a little something we could stick in our thumbnail cards. And Eiko's also really kindly working on a small little animation to feature into my educational videos when I get started with them, if I ever get time to do it. So that is where Newton the Owl comes from. He is my little mascot, which is to honor my little girl. So that's where that story is. My ex account. Thank you, Haley. Yes, that's my ex account. It is at Kiara J 2001. Yes, Eiko is amazing. I have done an interview with her. I've done an interview as well with Brad. Spoke to them both separately. Where in Eiko's, I showcased some of her family history and culture because she's Japanese Canadian. She is multi-talented. So many she's a music composer for films, an artist, a video developer. She does so many things, and we showcased a lot of her talents. Had a wonderful chat. She is really genuinely one of the nicest people I've ever spoken to. So do try and check out that video because she's amazing to watch. Why do we call her Lively when subpoenaed was compelled to use their legal names? Why do we call her Lively? Oh, you mean like her legal name would technically be Reynolds, but she has filed this. Her lawsuit is under the name Lively. She's entitled to use her unmarried name as well, and I think if I remember correctly, her actual name was Brown, and she legally changed it to Lively. And then she's obviously married, so she's now Reynolds. She can use any of those names. If you marry, you can still use your maiden name or any previous names you've had legally. And she's filed the lawsuit under Lively, so that's why we use Lively. I'm hoping I've answered that right. If you've meant something else, let us know. Back tattoo. Am I missing something? Who's got a back tattoo? What about the metadata in the New York Times? Is that done to English? Right. So the filing with the New York Times, I'm not sure what that was about. That was an odd filing. I can't get in. I'm not an expert in the recent filing requesting a declaration. So I think not actually Golden is probably a better person, or Little Girl Attorney. They're probably better people to understand that. I don't understand why the New York Times have done that at this point. The only thing I can think of is to try and shut down the possibility of an appeal by Wayfarer. The metadata is still going to be part of the defense. Like, just because Wayfarer's claims have been dismissed does not mean that it won't all form part of, all the evidence, all the claims that they had won't go forward and form the defense. Like, Nice Pool could still form the defense, because one of the questions that I had, and a lot of people had, was, and Brian Friedman outright said it, is, if your wife is being sexually harassed, why are you making a joke out of it? So stuff like that will all come back. The metadata, and we'll be showing this in the Van Zandt special on Sunday, the whole timeline, because it all happened so quickly within less than 2 months, really, of from Jen Abel's phone being seized and that phone call to Leslie Sloan, to Van Zandt being filed, to the subpoena, to Stephanie Jones, to the metadata showing that the New York Times were already involved and already working on the article. That all happens within a very short period of time. So I think Wayfarer will still be using it as part of that. But I do agree they should be held responsible. I completely and utterly agree. Wayfarer may be considering an appeal. I can't be 100% sure, because we don't know what is being said behind closed doors. A lot of people have asked, what do I think of the new lawyers that they've hired? One of them is quite a seasoned appellate attorney. That doesn't automatically mean that they are planning an appeal. They may be getting some advice, and the other person as well is a seasoned trial attorney. Well, we are now within 6 months of the trial, so it makes sense to have these people on board to be kind of, even if they're just sitting in the background, but they're involved in the process, because you don't want to hire someone when the time comes and then they kind of go into the role with no information, they've not been part of it. So to bring them in at this stage is quite a sensible thing to do, I think, but it doesn't necessarily mean that an appeal is definitely going to happen. I think you're talking about Aiko. Yes, you did spell her name correctly. Angel's voice. I have a back tattoo as well. Seems we're all going there. Christina, thank you for the links to the videos with Aiko and Brett. I'm just looking for more questions. Sorry. Oh, we're talking about owls. Okay. Is there any other questions? Have I seen pictures of rain-soaked owls? Oh my God, sorry. I have not. I will have to check that out. What does that mean, Christina? Oh, how have I been in general? Oh, I've been up and down. That's really nice of you to ask, actually. Thank you. I've been a little bit up and down. I did take a few weeks off. The subpoena knocked me for 6. I will be 100%, upfront about that. I was I worked flat out for weeks on the subpoenas, on multiple motions to quash and helping out with other people's, and got my own. The subpoena gate just absolutely wiped me out. That was really, really hard, and I did find it hard to get back into stride. I lost my confidence even. I don't know why I lost my confidence, but it was just like, I think it's because I had to. If it felt like it was re-traumatizing, to have someone want to go through all my personal information and everything again, and I didn't want that. And it took me back to the bad place in my own marriage where that happened before. And as I said before, I felt like I was the one being retaliated against. I was the one, like all of us content creators, a lot of us have stories of things that we've survived, and if anyone has experienced a retaliation campaign, I kind of feel like it's us. Because a lot of my content, whilst I express an opinion that I do not believe Blake Lively, and I talk about the law and what some things mean and what some of the processes are about, I also intertwine that with, here, this is what I've been through, and I talk about that. So to get a subpoena was a hard thing. I'm thankful that I have the knowledge and the skills that I have, that I was able to get through that. Otherwise I probably would have, struggled a lot harder. But yeah, the other thing that happened, which really knocked my confidence, was I filmed a video about my qualifications, and I really opened up and presented some of the text messages, Skype messages between myself and my ex-husband, and talked about the abuse in far greater depth. And some complete asshole entered the live chat with my mum's name, pretended to be my mum. And that was jarring, because I don't know how anyone got that information. And for a little while, I wondered if that was actually my ex-husband. I don't think it was, but that really knocked my confidence. So this is the last day or two, after a couple of weeks of taking a little bit of a step back, I've come back with newfound confidence, and I'm not going to be kind of intimidated. I'm here to talk about a case that matters to me, and I am going to stay put and talk about this case because it matters to me. And if anyone comes in pretending to be any other members of my family, they would just get blocked. I don't know how this person found out my mum's name. And it's not like my mum has a common name. Her last name is I'm half Danish on my dad's side. My maiden name is Danish. So, and we are the only people in the UK who have had that surname. I'm related to every other person with that surname. And her first name is, whilst more common, she's got an unusual spelling of it. So, and I just can't see that. I mean, plausibly, maybe it could have been someone from another country, but the chances that they would wander into my live stream on the day I'm doing the most personal video I've ever done, I don't think that was an accident at all. It felt very targeted, and it was incredibly unsettling, and my moderators were absolutely incredible and supportive, so I really thank them for that. But yeah, that's where I've been for the last couple of weeks, is just finding myself a little bit and calming down a bit. Thank you, Kay Bella. Angela, thank you so much. I'm incredibly grateful for that. Let's all get Van Sham tattoos. Van on the left, Sham on the right. We can do Wonder Woman thing and act like we're fending off bullets for them. Do you know what? I'll have to post a picture. On my left wrist, I've already got a tattoo. It's a butterfly. And it's coloured in. On one half of it, it's got like a, one of those charity ribbons that you get. And then that's got a wing on each side of the charity ribbon. And one side is the teal for sexual abuse, and on the other side, on the right side, is the purple for domestic abuse. And then it's got a couple of large sunflowers, because in the UK, one of the domestic violence charities that helped me was the Sunflower Centre. So that's my homage to my experience. But I love the idea of Van Sham tattoos. Thank you for that. Yeah, it's been quite wild. Oh yeah, girlie. No, I was absolutely scared. Just more than anything, because for a minute I was like, oh, could this be my ex? Has he found me? Because people were, back in May, people were really trying to find out who he was. God knows why, but people were, and it made me question, like, did people actually find him? Oh yeah, half Danish, half Welsh. Fantastic genes. So I've got Viking on one side, dragon on the other. Oh, thank you, Jane. Yeah. I'm debating it. One, because I've got to do part 2 of that video, to be honest. I've taken my time about it because it's a lot to pack into, to try and condense it down as 10 years worth into an hour-long video, is what I'm trying to do. Where I talk, and that one's supposed to be more about the actual abuse, and I think there's so much there. I'm going to have to do a part 3 instead of just a 2-part. But I am considering using just telling people my real name, because there's nothing to hide. The only thing that's really holding me back is I don't want people to find my current husband, because he's a mental health nurse, and he has to be really careful. Obviously, he works with psychiatric patients, and in his line of job, he is at risk. He's vulnerable to being attacked or stalked or threatened. So we try to keep his real name guarded. Anyway, despite all this, we do try to keep his real name guarded. So we don't have crazy people basically trying to find him, because God knows they do. Yeah, exactly, Neil. That's a good point. And I kind of fell into this rather accidentally anyway. I didn't intend for this to kind of all happen, but it did. I'm glad it did. I think I was underprepared for how to safeguard myself, but I'm learning as I go along. Oh yeah, it is, isn't it? Environment right now, and with stuff happening as well. And the UK, it's not even just America, and things like wild things happening, like the Charlie Kirk situation. Like, the UK is no better at the moment for feeling safe and so on and so forth. In fact, the UK is wild. I'm glad you mentioned that, Neil. I will be doing that. I'm probably going to do them as pre-recorded videos. Cassidy hasn't been too well. I will actually check with her to see if she's up for going back to doing something like that. Because that was our thing together. She wasn't well, and then I had my kind of time away from everything. But I have still got so many slides lined up. So I will see if she's wanting to do something. But one way or another, those old crime stories will still be going. I did the Jack the Ripper one as a pre-recorded. I got restricted because of I obviously used the post-mortem images of the actual of the murder victims. So yeah, I was restricted on it. It wasn't appropriate for children, which I didn't say it was. That was funny. Yeah, the UK is complete. UK right now, I could say so much. I try to avoid politics, but I do. I leave a lot of it to Steph, the alter nerd. I just say, she's got some good views. But the UK is a complete shit show at the moment. It's embarrassing. It's a shame. Hey Max, what are my views on Taylor Swift making herself available for deposition? I think it's ridiculous that she's not. I am a bit frustrated. There may be a genuine reason, but also she's kind of been implicated into this by Blake Lively. Now, one of two things has happened in this case. Either her friend has been sexually assaulted and she's not running to help her, or she knows that a man's life is being destroyed by false allegations and she's not rushing to help him. So I like Taylor Swift. I like her music, but I'm kind of disappointed that she's not making that time. It is important if she's got information. Blake Lively is the one that says she has information. So, I'm not coming down on Taylor Swift. It would be good if she could, sit for the deposition, because she hasn't got to do it in person. It could be done over Zoom. We saw that loads of times in the Johnny Depp trial. And it hasn't got to be the full 7 hours either, because if she's got limited knowledge, then she's not going to need to be there for the full time, just a few hours. I mean, I'm sure she could, and I hope she does. She's still got another week, but I do hope that she makes herself available. Thank you, Ashley. Yeah, I love streaming with Cassidy. She is just so easy, and she's quite softly spoken, so she is my energy. Whereas CJ was she had more energy, so she kind of amped me up a little bit. Cassidy is she's more chill and calm, and I just love talking to her. She's such a nice person. Steph is Steph the alter nerd. She's incredible. I love Steph. And the other person who does content creation on the UK, especially the politics and the law, because he's a barrister, is Daniel Shen Smith. He is the black belt barrister. He is such a nice man, really nice man. His channel is incredible, well worth watching. AI Taylor and Court, yeah. I think if no one's got any more questions, I'm happy to call it a night. I've enjoyed it. I was so nervous. I was hyperventilating at the start. I don't know why I get so nervous. Yes, Daniel is helping the girl who had her. Right. Oh, right. You are taking me down the rabbit hole. I don't get to say much about the UK, so I'm going to take this little moment to say it. A young girl. I think there's a bit more to the story. A young girl had two police officers. They turned up at her home and demanded to seize her phone because apparently she had viewed a social media post. Now, from what Daniel said, because he's updated the situation, because he's actually working pro bono, which means for free, for the family. He reached out to them and offered to help them for free. The police said something about fake accounts being set up that had sent quite serious messages. So I don't know too much about that, but yeah, it's kind of wild. I mean, I've seen a few of the police videos where people are being arrested in Britain for one person was arrested because he caused alarm and distress to another person by calling them a muppet. And I'm not even kidding. That video is on X. So oh, don't worry, I'm within the bounds, it's fine. I'm good with you. With the UK, I can talk myself out of that hole. Not a problem. But yeah, I mean, people. It's not that we don't have free speech. We don't have it as liberally as it like you have it in America. We have free speech insofar as you're not allowed to incite violence or hatred or false statements. But what's happening is what is being deemed as hateful and what offends people in the UK is just being stretched and stretched and stretched to the point where nearly everything is offensive, if that makes sense. I'm sure I'm sure Neil will kind of agree with me here. And the law needs to change because it's just getting ridiculous. Yeah, it's just getting absolutely ridiculous. Oh, well, there's hate speech laws in America where you can't say, I don't know anything about that. I'm sure the Americans would be able to say, yeah, Orwell's 1982. That is what we're living in. That is genuinely what the UK is currently like at the moment. So it's crazy. And it's not the nicest place to live at the moment. In all honesty, I don't love it here. Paul Harvey from the 1960s. Oh, okay. I'll have to look at that. Yeah, Angels, at least over here in the UK, there was a period of time where we couldn't call it breastfeeding because that was offensive. We had to call it chest feeding. The Supreme Court of the UK has stepped in and has sorted all that out now. So now we don't have to say all that, but it's there is some defiance to that law from our highest court in the land. We are being met with defiance from activists and from our own government. So yeah, Haley, I agree, they are They are messing with your First Amendment rights. Yes, chest feeding. We daren't offend anyone. And that's what I mean. The definition of words that cause offence is it being expanded. It's not that anything has particularly changed. It's just what you can get arrested for something that you tweeted 3 years ago. Which is wild because, you'd think that the police would be pooling their resources into solving murders and rapes and things, but no, apparently not. We have they are more concerned. The priority is, what did someone tweet? It's silly because it is. It sounds silly because it is silly. It doesn't sound natural. All right. Okay, everyone. Well, I've enjoyed that little. It's nice. Maybe I should talk more about the UK and UK law, and some of the ridiculous crap going on in the UK. We'll compare notes with America, see which is the worst country. I think right now the UK has won it hands down, but America's free to issue a challenge. Thank you, Neil. Always love seeing your face. Well, your little emojis. Yeah, UK does. I see. A fellow UK agrees. UK is is a comedy sketch, but it'd probably be banned as offensive, as most of great British comedies are being right now. And Roald Dahl books. I'm sure Neil remembers when they were when they were republished because it was offensive to call someone fat or to call someone ugly. Yeah, I agree, Christina. I love seeing everyone here. It's really nice that you all come and spend time with me. Nice little family. Bring back Father Ted, and I love Roald Dahl. Yeah, Roald Dahl. Yeah, exactly. I grew up with that. Do you know what I mean? I don't remember anyone being offended by his books 20 years ago, 30 years ago either. I don't know. Yeah, it's wild. Did I see the Ashley, did I see the UN? No, what happened? Someone needs to tell me what happened with the UN. Oh, I have to look to find out what the UN. Oh, Trump insults the UK and the UN after the teleprompter breaks and he speaks his mind. Trump kicked right off, told them this. Well, yeah. Sounds about right though, doesn't it? Right. I am definitely going to leave this time now. Thank you so much for joining, everyone. If you, like I always say, if you have questions, do I will check out the epic speech. Thank you, Neil. If you do have questions or anything, you can put them in the comments or whatever. If anyone's on X and wants to contact me, I think we've got to follow each other to be able to send messages. So if you just send me a message, like a comment on here with your X handle or something, and just say you want to send me a message, a DM through X or something like that, then I can add you. And if you don't already follow me, you have to follow me back, and you can send me a message with the question that way. And nos Daniel. Oh, Trump had a speech today, and it ranged from losing the real estate development to windmills to horrible London to every country is going to. Well, it does always go off topic a little bit, doesn't they? You kind of expect that with him, though. Thank you so much. I will see you all soon. I may still be, because obviously DFJ, myself, we had our question and answers on Friday. DFJ can't make it anymore because of work commitments. I think I wasn't sure whether I was going to continue it solo. I think I am. So if you do want to, if you have questions, by all means do come and come and chat with us, and I'll answer whatever questions I can. See you all really soon. Thank you so much. Appreciate you all. Thank you to my moderators as well. Love you all.